are taking a huge leap of faith from that punch system, as Kamal mentioned in the morning, till the stage that we have reached today. Question is that we really will have to make it a situation or a system that is more workable, that is more answerable, as also something which is really transparent by its very inherent nature. Now when we say how it can be influenced, I need not tell anything about it. We have spoken about privacy, and I am really pretty conscious of the fact that Mika has given me the limited slot and my esteemed colleagues are yet to speak on it. But trust me, when we really are opening ourselves to interference or rather dominance of artificial intelligence in our dispute resolution, it is us who need to take a conscious call. It is not a wrong call. Please don't misperceive me to be saying that we are taking a wrong call. But we ultimately, the fact remains that we are a populous country housing around 150 crore now. Most of our population is not that literate as probably all esteemed people who really have found their place here on various tables as also the rise. Nonetheless, the fact remains is that we remain in a country which really needs to take it a little more seriously when it comes to privacy and people's right, more particularly when those very people are completely obliviously living of their own rights. Therefore, let's begin with the very basic principle of privacy. Let's start respecting a person's right to be left alone. When we are to apply that as compared to AI, artificial intelligence would depend on feeding of data. The data that probably comes from people like you and me. People who really have a voice, people who really are capable enough to put forth their views on various aspects. But then we are in minority as compared to the populous situation that prevails in the country. And therefore, if we want it to be workable when it comes to interference of AI as compared with the conflicts with privacy, first let's go to those people who really need to get educated, who on any given day. Today, I would not want to cite data or number of people, etc. But trust me, the number of applications which are, so we are in an era where cricketers tell us with regard to benefits of gambling. While we have this onslaught of IPL going on in the kind of advertisements that come, you would find all the cricketers really espousing sites which otherwise are promoting gambling and nothing else. Then we have actors who we idolize, who tell us to drink kind of drinks that we probably should really not be subscribing to. It is that kind of a situation that prevails in the society. Let's make sure that AI doesn't really come into play when it comes to educating people. It is only after that they are educated we would get benefits of AI, which really applies algorithms, processes the data which is fed in it, which is free from any biases, alterations, hacking, and as Kamal will say, and also facilitates normal people to reach solutions before they reach a competent court of law. That's how I would want to put it in overall prospect. Of course, my elite panelists would say a little more on it, and I certainly promise you to come back on this. Thank you so much. Thank you so much.
Thank you, Devang Bhai, for those enlightening word and opening remarks of this panel discussion. What we hear you loud and clear is that we have to be cautious, but at the same time AI is beneficial. AI is always binary assessment of all the data which is fed into the system. So it is as good as the data which makes it happen. So there is always going to be some element of bias. But I want to ask Mahesh, he just told me that he wrote an article for Singapore newspaper on the very same topic. So he has done the in-depth analysis of this topic coincidentally. And what we hear is that AI is a very, very powerful tool in the dispute resolution, especially for analyzing large volumes of data. We have international arbitrations, we have bundles of documents to be analyzed. E-discovery processes are there, and identifying the patterns and trends for maybe valuation or coming to a particular conclusion in the arbitration. Without any cognitive biases, because we don't need a human element there. Of course, we'll come to the decision making and whether AI can be an arbitrator or a judge. But when it comes to pure, simple analyzing of data, what are the precautions and cares which we have to take, as Devang said, that we have to be very, very cautious to avoid any unfair advantage or discrimination against one party in the dispute resolution. Because in dispute resolution, we always have one party maybe having more bargaining power or an edge over the other party. And we keeping in mind the time and cost the AI can save in the arbitration process. What are the pros and cons, Mahesh, you will guide us to keep it in mind.
Thank you.
Can you hear me? Yeah. Thank you very much for the question. I will first touch on the benefits of deploying AI in dispute resolution, and I think there's no better way to show it than by way of example. I think in 2018 there was a startup that was called Law Geeks that ran an AI program to review hundreds of non-disclosure agreements, and they pitted that against actual lawyers, employment lawyers who do this as their bread and butter. The AI took 26 seconds and the lawyers on average took 92 minutes to review each NDA. And the AI came up with a 94% accuracy, whilst the lawyers came up with an 84% accuracy. So that in a nutshell, you can really see there is greater accuracy or potential for greater accuracy. There's great potential for saving of time and cost, because unlike lawyers, the AI hopefully does not bill by the hour. And so that you already see in one example, the ability to process large volumes of data. And in the UK and in Singapore, I argued the first case which implemented predictive coding in e-discovery. That really means you select thousands of keywords and you program it into a code, and you run that code against terabytes of data. The first level of review is done by lawyers who will say relevant, not relevant, and then they'll put it into separate baskets. The AI then learns from that, the machine learns from that, and runs that program again. Then there's a second level of review. So it is helping us do things that were not possible before. In the past, a discovery like that would probably take 2 years. Now it can be done within a span of 4 to 6 months. So much so for the benefits of AI, and also, as Tejas just pointed out, there is arguably greater objectivity because the AI is just a computer program, so it doesn't bring with it certain historical hang-ups or certain biases that it has. But that is also a double-edged sword. So that's where we come to the question of the risks of deploying AI. And I think the best example of that is if you look at when you take it to its extreme, the question everybody is asking, is artificial intelligence going to replace lawyers and judges? In 2016, in Wisconsin, a gentleman by the name of Eric Loomis was sentenced to 6 years imprisonment for a felony crime. Now, what was odd about that case was that the prosecution and the defense had actually come to a plea bargain that I think they were put him behind bars for just 6 months. But the sentencing judge used an artificial intelligence tool called Compass to assess recidivism. In other words, how likely is Eric Loomis to commit the same crime again? And the AI came up with a certain score, and based on that Compass score, the Compass program score, the judge sentenced him to 6 years imprisonment term. Now, there he challenged the sentence on appeal, and part of the problem already is when it comes to legitimacy of AI decision making. Eric Loomis simply could not criticize what were the factors that went into coming up with his Compass score, because this is what we call the black box of AI. Human beings, or most human beings, do not actually understand the inputs that go behind what is the output that the AI program spits out at the end of the day. And the Supreme Court of Wisconsin upheld the sentence by saying that in this case, the judge did not substitute his decision making but he merely used that as one of his tools. Obviously, it left a sour taste in the mouth of everyone who has actually read about the case, because you can see the plea bargain was for 6 months. He was sentenced to imprisonment term for 6 years. And you will hear this again and again on this panel, which is that the AI is only as good as the data sets. And unfortunately, we are going to see the ghosts of our mistakes past living amongst us, because our data sets, especially if you take, for example, the criminal justice system in the US, it is tainted. It's tainted with systemic racial inequality when it comes to sentencing people, colored children, people from minority backgrounds who come from inner cities, single fathers, drug abuse backgrounds. If you feed all those inputs into a Compass AI again, the Compass AI will actually say, lock this person behind bars for a very long time. So there's no room for actually tapering the decision to the individual at hand that is before the court or before the arbitration panel. So that's where I think we need to be very careful, because you're punishing the individual not for whatever that individual has done, but for what individuals before him have actually done. And I think when it comes to precautions, we need to bear in mind that because of the current limitations of artificial intelligence, it's merely an aid still. It's not ready to be a replacement. And another aspect that often comes up in international arbitration, I think, is economic disparity. If the dispute is of a large quantum and both parties are represented by, one side is represented by a senior counsel from Singapore, the other side with a senior advocate from India or a QC from London, all is well and good. But what happens in a situation where you have one party that is from a first world country, for example, like the United States, and they're pushing for predictive coding to be used in the e-discovery process in international arbitration, and the other party is from a third world country, right? It's from a poor nation, simply can't afford it. So in that sort of situation, we need to be alive to the economic disparity that is still prevalent in the world before we push out these AI tools and force it down the throats of lawyers and judges. And I think that's where we need to be careful, because it's not just bias, but it's also disparity that comes up again and again. Thank you.
Thanks, Mahesh. And before we go ahead, we would like to acknowledge presence of Honorable Justice Shabin Devani. Welcome, ma'am. We are lucky to have you. So, talking about AI, we all heard that it helps in dispute resolution, but we have to also talk about the legitimacy and economic disparity, because it's not that everybody can afford AI and to what extent it can be misused. Similarly, when we talk of confidentiality and privacy also, there are huge concerns. Now, privacy is a fundamental right as declared by the Honorable Supreme Court, and especially in the form of arbitration, we always have seen that confidentiality and privacy are treated as either twins or siblings. So if I may ask Mr. Shashank Jain, what are your views? Are they really twins or siblings, or what are the global experiences with the respect of interplay between privacy laws and arbitration?
Thank you so much, Tejas, and thank you MCI for inviting me for this event. And it's indeed my honor to be in presence of such a great panel with such big names from the industry. I'm actually a data privacy professional, and I manage the data privacy program in my organization, so that's a topic very, very close to my heart. So I actually think that they are same but different, as how you would approach me to shopkeeper, they'll say they're same but they're different. So that's actually, I think, what they are in a nutshell. And what I mean by that is that in a context of arbitration, we may use privacy and confidentiality interchangeably, but it's actually different. Because privacy would mean that proceedings are held in a private kind of a manner, in an in-camera manner, and confidentiality means that you will not be disclosing the information or whatever the award is, except in a certain set of circumstances which is permitted by the laws, such as enforcement of the award itself and so on and so forth. So that's different. But then if we take it to a different level from a data protection perspective, and if I put it from a lens of the digital data protection bill that's pending, that we are all expecting very, very eagerly, or which draws from the European Union's EU GDPR law, it's again, it takes a different perspective altogether, because in that context, privacy means privacy of a person, and that person has to be a natural person and not a company. So it's basically your privacy, my privacy, as Sir was mentioning right at the beginning of the conversation. That was about a person, and that's what the scope of that law is. But in the arbitration context, it's different. So there's certainly going to be an interplay that's going to happen between the data protection law that we are all expecting and in the context of arbitration. For example, we have to think of issues such as if things can be exported. So there's an international commercial arbitration happening, say for example in London, and there's a party here in India. Under the privacy law, there's a requirement to do data retention here in India. How are we going to export that data, for example, to the United Kingdom for the purposes of evidence, for example, or things like that. So those are the kind of issues, I think, which are going to emerge from this particular context. We also, if we take a step back and look at the provision of the Data Protection Act, bill rather, and that kind of gives some kind of flavor as to when it would be kind of permitted. So in the context of data privacy, we call it as data processing. So if any person, so there are two concepts in privacy, controller and a processor. So a processor would be, for example, an MCIA. So there is someone who has to give evidence about a particular person, and there is a personal data of that person involved. So that data has to be processed. So MCIA becomes a processor. So the question arises, does MCIA need to comply with this particular statute? So those are the kind of questions which are going to come about, and the law has some kind of exemption around it, but it's not exactly clear in context of arbitration whether arbitration would be exempted completely from application of that particular bill as far as processing of that data goes or exporting of that data goes, because there's going to be mandatory requirement here to retain that data in India. Now moving on to another kind of topic in the same light, and that's got to do with ODR, which is the online dispute resolution. That again brings the question of privacy and confidentiality together. And I'm privy to a particular case where there was an international arbitration, commercial arbitration by one of the another very prominent center was going on, and some person was giving an evidence remotely. So they had to do like a hell lot of work to ensure that there is a proper mechanism, that there is no kind of breach, there is no hacking. So they actually installed, so for example, the witness was in a room and they had to install cameras in all four corners to see that there's no one else in the room except for the authorized people in that room. They sanitized the room before the evidence began. There was a particular form of oath that the person had to take. So all of these steps have to be taken in context of ODR and things like that we go on to leave with. It's quite common, for example, for all of us to have court proceedings online, and the Honorable Supreme Court has also noted of situations where people have made recordings of the court proceedings and have broadcasted it, and they're not all right with it. But those are realities. People are doing it. So to what extent do we stop it? How do we regulate it? How do we do it? So I think it's going to be quite interesting, and we'll have to look at both confidentiality and privacy from a slightly different lens, and we'll have to be very agile to move that lens and to kind of change the focus every time we look at it from a different perspective, because these are not simple matters. There's a lot of technology that's behind it, and unfortunately, or the way things work is that there's always a situation and the law follows. So that is something that will kind of continue. But as lawyers and as decision makers, sitting as there's so many judges and other very eminent people who are in the judiciary who are here, so we'll have to kind of continuously focus and refocus and look at all of these things from different lens and perspective. Every time a matter comes and see how it develops. It's not going to be a one size fit for sure, and we'll have to continuously treat them separately and as different. So, thank you.
Thanks Shashank for raising so many interesting aspects when it comes to confidentiality and privacy. And basically what we have seen is we can use technology to also protect the privacy. We can have two-factor authentications or the encryption, which can definitely help to protect the privacy of the users. And once the data protection bill is enacted, that's going to completely change the way a lot of businesses are functioning today, because we are not realizing the value of personal data and how to protect it. And once we have those guidelines in place, it will going to impact a lot of stakeholders, even in the field of arbitration. And when we started with pandemic, we have moved drastically towards the online dispute resolution mechanism and virtual hearings. In a recent survey of Queen Mary and Viking case, more than 80% participants agreed that they would prefer online hearings or virtual hearings. So if I may ask Anurag, your views are there any rules of any institutions or guidelines or in the nature of soft law which are framed for use of technology while of course safeguarding privacy and confidentiality in arbitration? Do we have some framework or guidelines in place when we talk about confidentiality in arbitration, especially in the field of virtual hearings?
Thanks, Tejas. I think you have touched upon a very relevant thing today, that how we have to, how we can restrict the confidence or ensure confidentiality, privacy, especially in this age where artificial intelligence is taking over almost all the facets of our life, including justice delivery system. So when I actually was examining this aspect, I found that there is hardly any law right now in India which regulates use of artificial intelligence in either judicial system or alternate dispute resolution, that is mainly arbitration. So we are actually relegated back to the same general laws which actually control the judiciary or the judicial function and the arbitration. I found that section 19 of our Arbitration Act very clearly says that it is all about procedure. So the procedure has to be determined by the arbitrator with the consent of the parties. That is the fountainhead of this arbitration system in our country. And similarly, I found that even in CR and our host MCIA has also published the rules, and they have also said the same thing, that the procedure has to be adopted by the arbitrator, either with the consent of the parties, and when there is no consent, even then arbitrator can decide or arbitral tribunal can decide upon the procedure. Now, I think in my personal view, this provision is sufficient enough to incorporate the aspects of artificial intelligence as well. Because if the arbitrator today decides that he has to make use of the artificial intelligence, then nothing prevents him. No law actually prevents use of artificial intelligence in justice delivery system. And it was really good to see that Honorable Punjab High Court has actually, one honorable judge has actually used ChatGPT and has acknowledged that in the judgment itself, that yes, he put that particular question or query to ChatGPT and this particular answer he got. And after that, and rightly one of the co-panelists also mentioned about one case of foreign jurisdiction where a person was actually given enhanced punishment because of the feedback taken from the artificial intelligence tools. So in India, I still feel that there is sufficient provision, or the generic provision is sufficient enough to regulate or incorporate the use of artificial intelligence in arbitration proceeding. Now coming to the second aspect which you mentioned about the confidentiality. What about privacy and confidentiality when there is use of artificial intelligence? Now, there is a dichotomy between arbitration proceedings and the judicial proceedings in India. In arbitration proceeding, I found that MCIA rules, even SIAC rules, talk of confidentiality, and after 2019 amendment in Arbitration Act, the aspect of confidentiality has been introduced for arbitration proceeding. But unfortunately, or incidentally, I would say, I am not criticizing, incidentally, for judicial proceedings, there is no such confidentiality clause anywhere. Rather, the Code of Civil Procedure says that the court which is trying a particular suit will be an open court. So it will be accessible to all. So in one particular set of proceedings, we are saying that confidentiality has to be maintained. In the other set of proceedings, which is more acceptable to the world at large, that is judicial proceeding, there is no such terms of confidentiality. Now consider a situation where an arbitration award is challenged before a court of law. What will happen? Whether that will become confidential or that will not be subject to confidentiality. That is a subject matter of debate actually. So till now, and there is another aspect, that how artificial intelligence has been trained so far. Only because of the availability of the past records, since High Courts and Supreme Court is the courts of record, are the courts of record. That is why there is so much of data or the earlier proceedings publicly available, on the basis of which we have always been training our artificial intelligence. If we impose this restriction of confidentiality on the judicial proceeding, what will happen? From where the artificial intelligence will get future data? There will not be any avenue, because you have already restricted the use of that proceedings for any other purpose. So actually, for public at large, for public benefit, actually it makes sense to make some part of even the arbitration proceedings open to public viewing. Because we are not creating any database only. I don't find any place where I can see that how many arbitration awards have been passed by a SIAC or maybe MCI. So how the young generation of lawyers will come to know that what is happening in the judicial system, which has been the case because just by reading some judgment, or it is easily available, people are training themselves. So we have to be very careful in enforcing confidentiality and privacy, especially in this field.
Thank you. And you're absolutely right when you say that the confidentiality can prevent the dissemination of information about the arbitrators or their views, or the creating a precedent value. And the answer to that could be redacted awards. The ICC has started with redacted awards, and even DIC is considering to publish their awards in a redacted form. That may create a database and add to the whole aspect of artificial intelligence. Now, artificial intelligence is also used in the procedural aspect of arbitration. It could be for transcripts, the translations, or virtual reality, which can be shown to the arbitrators without even visiting the real site or any project. They can see exactly how the breach has happened, or how the facts can be narrated in a very different way. So if I can ask Mahesh that what are the ways in which the artificial intelligence is being used globally, because you have a view of the India from outside perspective, is that whether we are lacking behind or we are catching up, because what we think is artificial intelligence is a thing of reality and not future. So what is the state of affairs now from the global perspective?
Thank you. I think in terms of looking at the use cases for artificial intelligence in arbitration, you have to consider the entire life cycle of the arbitral process. So it starts with document review, management and discovery. And I think around the world, in most of the jurisdictions that have adopted it, you have software like Epic's e-discovery software or Relativity One. These are basically all like platforms that are hosted where you take custodians, right? So individuals in an organization, they will upload the entire email database up to this e-discovery platform. And from there, we will use machine learning tools to conduct the first level of discovery, and both sides will have an input on that. Now, in terms of, I think Tejas' question is important on how is India faring when it comes to that. I think it has come up in two. Of course, the dispute needs to be large enough to justify the cost of deploying this kind of software, because you have to pay a monthly subscription to host the data, and then there's, you have to pay X dollars for X number of users, for example. I think it's come up in the past 10 years, at least for our firm, twice. The problem that we found was that there was very poor document retention policies, even amongst leading companies. So, whereas if you were to find in some countries, like in Singapore, for example, you have a 5-year, 6-year, 7-year document retention policy. That means that even when an individual leaves an organization, the PST file, which is all of the emails archived for that particular individual, is then uploaded and is actually stored for a period of 7 years. In India, for Indian-related disputes, we found that sometimes when the individual leaves the organization, the data goes missing. So that in itself is really hampering the deployment of machine learning tools when it comes to document review and document management. So I think that really is the first step towards where you have complex disputes, where you have large amounts of data, to deploy these tools which are already accepted. They've been accepted for about, I think, close to 10 years now internationally, to use them in place of young associates to actually review those documents. So that's the first point. The second point would be, I think the second step would be using evidence which is AI driven. So I think in 2018, the Chinese court has actually issued a directive saying that blockchain evidence is admissible in their internet courts. And in Singapore, we've had a flurry of blockchain cases as well as cryptocurrency cases. And no one has actually raised the question as to what is the level of admissibility when it comes to blockchain evidence, because everyone just assumes that blockchain evidence is less susceptible to being tainted as opposed to physical evidence. It's immutable, it's on-chain, it's not time sensitive, and when an individual leaves the organization, it doesn't just evaporate into thin air. So that's the second step, which is accepting digital evidence as evidence in court. And I think then you have, I think, the more complex areas, which even though there's a lot of buzz around it, and a lot of law firms have actually beaten their drums and said, oh, we're deploying AI in international arbitration hearings. But when it comes down to it, what they're really doing is that they're using some tools that assist with the presentation of evidence. So you use artificial intelligence or tech tools to simulate what has actually happened. So in a dispute that we did where an accident happened on the high seas, we used various inputs fed into this machine that could actually churn out a CGI of the accident on the high seas, how it actually happened. And visualizing that, I think the arbitrators, 3 arbitrators, said that was the best thing that they understood about the dispute, despite the dispute having gone on for about 24 months and them having to read thousands of documents. So that is really the current state of play. But what's the next frontier? You could have, they are already developing tools which could, for instance, review all of your documents, churn out a first cut of a chronology of events, churn out a first cut of dramatis personae. Right now, my team is doing the Terraform Labs representative actions, a class action suit against Do Kwon and the people behind the Terra USD. And we've had to use some machine learning tools because we have about 400 claimants. And when particulars are asked about each of these 400 claimants, there must be a simpler way of organizing it. And that really is the base level of artificial intelligence that we have right now, which is you have certain amounts of input, the machine then presents it in a way that normally an associate would take weeks to actually do so. And then lastly, in terms of hearing, I think it's quite aspirational to say virtual reality hearing, because I don't think anyone has done that so far. But what they are trying to do now is AI-driven live transcription instead of having human transcribers, as well as the very tricky problem of simultaneous translation from one language to another. that the second aspect, I think, is something which has not been cracked yet, but if it can be cracked, then it will save a lot of time. It will actually half hearing time, rather than having a human translator translate back the question and the answer. You would half the amount of time that is taken in arbitral hearing. Thank you.
Thanks, Mahesh. So, absolutely, because wherever we can remove the human element from the task, we should do that. But there are certain legal concerns relating to the involvement of artificial intelligence. And what are the safeguards we can, if I can ask Shashank to quickly share his views, because we are running short of time.
Sure, thank you. So very quickly, I think let's take a step back and think about that what is actually artificial intelligence. There are actually two kinds of it. One is a weak one and one is a strong one. Weak one is where there is an algorithm you put in and it does predictions. For example, everyone uses Gmail. You start typing an email, and when you type, it starts to guess that what is this exactly you should be typing next, and it learns from you. That's it's doing on the basis of an algorithm. That's the less tricky and the complicated part. The trick comes when the algorithm is not under your control. So the algorithm is the machine itself is developing its own algorithm and is thinking about it and is coming up and has a mind of its own. It's not that any software programmer or someone can do anything about it. That, I think, is the more problematic part. I think as humans, we see and if we think about origination of law and how law has progressed, law is there as in place to regulate society and to see how society is at a particular point in time. As we all know, society is always evolving, it's always developing, and one of the main reasons for development of society is diversity. So if we were to kind of restrict ourselves and be completely dependent in the area of dispute resolution, on artificial intelligence, I don't think it's frankly a very, very good idea, because it in a way has a potential to stop development of laws and to change thinking, because it's always going to look back at the precedents and have a think about it. Okay, this has been done in the past and this is the exact same way things need to be done in the future as well. In the context of arbitration itself, Bhartiya International is like a classic. And we know how many iterations have been there of the principles that are there in that particular case. It's not something to be repeated. All of us probably know it by heart. It's the law is continuously evolving to suit a particular situation. Another aspect is human emotion and human feelings and instinctiveness. Now those are aspects which are very, very important, which at least from my experience in court, I have seen that judges and lawyers who present cases, they continuously apply, and that comes out of it. A good example, perhaps not in the Indian context but in the American context, is the jury trial. So jurors are selected with a particular thought process in mind. They're struck out with a certain thought process in mind to get a particular result. Their biases are kept in mind and all of those things, because biases I don't think is a bad word. We all think of bias as a bad word, but I don't think bias is a bad word, because it makes us different. Bias is a distinguishing factor, perhaps. It's which helps in development of our society. And artificial intelligence, to my mind at least, and my limited understanding of it, is it takes away from that particular perspective. That said, I think artificial intelligence is a good thing. We should implement it in small bits and pieces. Before we have something which is more predictive or has a mind of its own, kind of an artificial intelligence, we should have a regulation or something in place, and we should examine it and bring it forward in a phased manner, instead of just rushing into it that we got to do this, we got to look cool. I think we have to avoid that temptation. Those are my thoughts.
Thanks. You said artificial intelligence having mind of its own. So if I can ask Anurag, can artificial intelligence itself can be a decision maker? Can it replace the arbitrators, and can we mitigate this risk by using AI with a monitoring and evaluation of AI? What are your views?
So most interesting question, I believe.
And again, if you can be brief, we have.
And Devang bhai is asking me to say no, it cannot replace. So I'll cite one example. On this, what happens when, say, 5 years back, did we ever imagine that a car will be driven without a human being? The answer would be no. Even 5 years back, perhaps we never imagined and perhaps we were not ready to believe. But now it is a reality. Car is being driven by artificial intelligence machines, and mankind, human beings, are happy to be in that car and feel confident that okay, my machine is driving my car and I am safe enough. So when that is happening, what is the artificial intelligence doing actually? Is it not taking decisions, making decisions? At every point in time, it is making a decision whether to slow down the car or to speed it up or to stop the car or to turn left or right. It is making decision. Now coming to the dispute resolution side, since I have spent 10 years in courts and rest 15 years roughly in BFSI, banking and financial sector, which Honorable Advocate General, I was happy to hear him that he is actually mentioning this industry. Why I am saying that? That today we have more than 5 crore cases pending. And being in the court, I have seen that most of the judges at the lower level especially, 90% of their time actually is going into routine and mundane jobs. They are not adding value to it, and they are not spending enough time to make decisions. Actually, they are spending time on the routine things. So, if we really implement this artificial intelligence, use this artificial intelligence, it will actually lessen the work. Typical example is 33 lakhs, 138 cases are pending in Indian courts. Now, is it not consuming enough time of the scarce resource? Scarce resource means judges. They are a scarce resource. And they are not supposed to do those mundane jobs, clerical jobs every day. So if we really implement artificial intelligence aggressively, actually it will take care of a biggest problem in our country on the judicial side. That lessening of the court cases or reducing the burden on the judiciary. Now coming to the last point, whether it can replace the arbitrator or it can replace the judges. My answer would be yes. I'm sorry, sir. My answer will be yes. 90% of the court cases, I feel that within next 3 years only you will find that 90% of the court cases which are repetitive can be decided by machine, that is artificial intelligence. Yes. And it is ultimately going to be a challenge between human race and mankind and supremacy of mankind over the machine. So, when you free up the resources, the scarce resources or the human resources from the routine jobs, actually it will be employed or deployed for a better management or better utilization of the workforce. The same thing happened when you introduced core banking system and computer in banks. The same human trial. Whether computer can replace the teller person who was sitting behind the window. The same thing happened, and it really replaced everything. And I mean, nothing is heaven has not fallen, and everything has really gone for a better thing. We are living perhaps in a better world and more systematic world. So the kind of volume that the judicial system is generating, it is not possible to handle it without the artificial intelligence. The only caveat is that humankind or mankind will have to evolve itself so that continuously it remains one step ahead of the machine and continue to supervise the machine. That's all.
Very interesting. I'm sure Devang has a different view. But before we go ahead, I wanted to ask audience by show of hands that how many of you think that artificial intelligence will replace the judges or arbitrators? Any guess? Oh, okay. Very few. Okay, but there are some of you who feel that. So Devang, over to you. What are your concluding thoughts on this? And before we turn to the audience for Q&A, I'm sure they are having a lot of questions for us.
There is no conclusion on this, but nonetheless, let me say this, that of course, as Anurag said, that we have self-driven cars, but then we as a country are a self-driven country, and there is no artificial intelligence involved here. It is all human intelligence. We are not a country who is up for artificially intelligent self-driven cars. We really will have to put ourselves couple of pedestrians up. in terms to reaching that situation as a country, as a nation. And that is all that I was trying to flag when I say that it is not that anybody is averse to this. But then trust me when I say this, that the human tendencies are beyond comprehensions and they are beyond any plausible algorithms that probably AI will ever come up with, because if I am to allow my matter to be decided by an artificial intelligence system, trust me, the very discretion of a judge is being taken away. And that is exactly where my difficulty with this whole system would start. It has to be supplementary, it can never be as an alternate. When we talk of justice is one thing, when we talk of dispute resolution is another. Dispute resolution is all about numbers, if that is what one is to perceive. Probably AI may attain a greater role. When it comes to doing justice, trust me, it is the judges who do that, because it really involves a lot of heart and soul, and it does not only involve any intelligence, be it artificial or otherwise, because what happens is that the judges, when they reach there, you have no realization that the amount of time that they have spent at their very profession is more than 25 years, sometimes 30-35 years. No, artificial intelligence is probably, artificial intelligence will only process the data that is fed in. It has no room for discretion. When we say bias, when I flag the issue, as I distinctly recollect, Mahesh also spoke of complexity of human mind. We also had Prashant talking about flagging certain issues. One of the issues that I always wanted to flag is, it is not that anybody is averse to it. Question is, how are we ready to really adopt these things? We are ready. We are a country which probably has maximum exposure to the technology, as also in terms of providing internet speeds and access. At the same time, we really depend on the data that is fed in a system, and then we really can't allow that system to decide, because my idea of justice is very simple, which includes lot of things over and above the algorithms. Algorithms by influential people can be manipulated. We are living in a digital era where things are really more susceptible to alterations and hacking and all that, which probably a human mind still is not. At the same time, I would subscribe to their views that yes, intelligence, be it artificial or otherwise, is the core when it comes to doing justice. Let's rather start focusing more on intelligence part. But when we talk of artificial intelligence, let's be sure that we really are not exposing ourselves to some algorithm which is beyond your own comprehension. You don't understand how your mobile works, except for calling and answering and other things, couple of things that you do. The algorithms are a technical term which a person at helm of affairs, be it government or otherwise, even I intend to represent government nonetheless, it is an algorithm which really is susceptible and is very open to alterations by people who are either influential, powerful or resourceful. Let's make sure that that doesn't really affect the outcomes. And when we talk of outcomes, let's leave it to judges. And let artificial intelligence play a supplementary role and not the main role. And that is exactly how I want to flag these issues. Please don't perceive me to be against artificial intelligence, but then again, as I said in the beginning, anything that is artificial, I am not up for it. Let's make things real. That's how it is over to you, Tejas. I'm so sorry.
Thank you. And it was a great real discussion we had today on this artificial intelligence issue. Of course, there are views and there is difference of opinion when it comes to use of artificial intelligence for certain aspects of dispute resolution. We have more to achieve in years to come, because if the algorithms are good, you can have reliance on the technology. Technology is here to stay. We cannot do away with the technology. So to what extent we can use technology is something we have discussed today. Over to you for questions. I'm sure you have some of the questions here. Please go ahead. We have limited time, so
we have scary number of heads coming up.
Please introduce yourself and please ask your question.
Good afternoon, everyone. I'm Tanya Gupta. I'm from Joby Mathia and Associates, Mumbai. I'm grateful that I could witness this amount of opinion coming from the panelists regarding AI and privacy, especially from a generation before me. So for a young practitioner to see that even a generation before me is quite concerned about these issues, it really makes me happy and it really makes me concerned at the same time. Coming to the question, so it's on the basis of what Mr. Vyas and Mr. Rai had stated. So my first question is directed to Mr. Vyas. In the beginning you mentioned that instead of a smartphone, you would rather be happy with the old time phones and you would rather just use it for calling purposes. But given the current situation, I understand that the smartphones were actually introduced for the sake of convenience of communication with people, with your family and friends. But then again, today, with the ongoing pandemic and with the lockdown that had started, today I understand that even our work is committed and concluded with the help of smartphones and tablets and laptops and online facilities. So in that case, sir, in your opinion, do you think that maybe a statutory authority specifically for AI and data privacy, if put in place, that would be quite helpful for next 20 years maybe? Its implementation might of course take some time, but do you think something like that, a structure like that might help India to accept AI as well as to move ahead?
Good morning, Anand. First of all, it was really a pleasure to hear that we are in earlier generation. No, we are not. We belong to the same generation. Probably the number of years is the only difference. And trust me, I am exact number of years younger than you, as you probably would find between us. So let's not digress. That's not the point. I am not averse to use of phones or technology or AI in that sense. Please don't misunderstand me. My idea is very simple. My idea of telling you that I don't use an iPhone, of course I do, along with the analog phone. The technology, in my belief, is always in supplement to my basic perceptions, because my behavioral patterns as a human being are way beyond any algorithm of artificial intelligence which works or operates on the basis of the data that is stored in it, which learns from me out of my human behavioral patterns. But then are you really in a position to say that because I am using a smartphone, it means that my behavioral patterns are now known to the smartphone? The answer is no. I am not averse to smartphones or the technology. I really welcome it. Idea is very simple. We belong to a system which is dominated by a huge population which really needs to gear itself up, is one part of life. The second part of life is that these technologies must come to my assistance. But then I really am averse to the idea of it taking over. So when I say that yes, I use analog phones because I want my privacy to be protected, that is the focal point here. When on a cell phone that you are using and claiming it to be smartphone, which ultimately has an impact of making you dumber as a person, that smartphone really makes you dumber when you really submit that I agree button without actually having reading it. Even lawyers don't read it. When we preach things to others that you should not have signed a document without reading it, we end up submitting that I agree button. That is exactly what I am averse to, because when I really am really pushing that button that I agree, I am not only agreeing to downloading of that application, I am agreeing to my very private data being amenable to be shared. Now consents, as you say, I am only giving consent for my data being used by that particular app. Now that particular app has its own algorithm. So it is like going to Netflix. You like a movie and trust me, 10 movies on those lines would start coming to you. There's something similar to this. It is all about that taking over my life as an individual. My idea of life is very real, very simple, and that idea is that I need to be at helm of affairs with assistance of the technology, and I would want to make life better using that technology instead of allowing that technology to start deciding for me. And therefore, please don't perceive anything to be a generational gap or anything. None of us is old. Of course you are young, but then we are not old. Thank you.
Yeah, we'll come back to you. We need to give opportunity to others also. Yes, we can.
A very good afternoon to one and all present here. I'm delighted and thankful.
You have to be very quick in questions.
Yes.
We are running short of time. No chance for any comments.
So I have one open question for all the panelists present here. If you are given an option of using a legal tech tool which is AI driven, but the catch is it is in the form of human in loop approach, where the human arbitrator is equally involved while throughout the process of using that tool for deciding or adjudicating the dispute at hand. What the tool will do for you is based on the input, like the agreement, the contract, if the statement of claims, defense, evidences, documents which are submitted to the tool or uploaded, the tool will analyze and based on the legal analytics, machine learning process, and also using the NLP method, it will fetch out the relevant case laws, the relevant statutes for you, and this is the first step. Now the second step comes.
What is the question? Yeah.
I'm asking about whether the arbitrators or the panelists here, present here, will be keen of using this legal tech tool, which is AI driven but moderated in the form of human in loop approach. And also the second part, which is it will also give a predictive analysis where the arbitrator will be involved equally in the process of asking questions to the tool and analyzing its likelihood of outcome of the present dispute.
Thank you.
Yeah, the first part of your question is already being done actually. So you have, you all have heard of Westlaw and LexisNexis. Now they have, I think, K-Stacks, which does all of that predictive stuff. The only thing is the last aspect. What you are thinking about is a final step, which is a chat GPT but for lawyers, right? Where you can ask questions on the basis of what the software has actually pulled out in terms of case law. That hasn't been done yet. That's also because, as you all have read, ChatGPT and Bard, they have a tendency to hallucinate answers and lie confidently. So they haven't gotten over that first phase yet. So let's get it to answer Google questions properly first before we start implementing it in the legal sphere.
So I would like to give an input here. Like ChatGPT is using the general data which is available over Google, but this tool, if it is using the legal databases, the actual authentic data, and based on that it is giving its analysis. So what would be the outcome will be of more accurate and more transparent and better in nature than ChatGPT is using or doing.
I think the point really is that the large language model technology has not evolved to the state where it has actually managed to iron out the accuracy issues, right? So that is even when we talk about ChatGPT, or I think some law firms are trying to implement that when it comes to legal research. So I think more needs to be done in terms of the fuzziness of the answers. Right, and its ability to cook up data, for example. Right now, the makers of ChatGPT are facing a defamation suit because ChatGPT answer wrongly implicated a politician and said that he had gone to jail for something when actually he hadn't. So we need to iron out those, we need the next step to be taken first before we can implement it. But in theory, there's nothing wrong with what you are saying. In fact, it is already being done. And I think in the Singapore Judicial College, they've already started looking at using artificial intelligence to help judicial decision making. And that could be using all the vast data sets of all the case law that's reported in Singapore and the statutes.
Thank you so much.
Okay, with that, thank you so much, all the panelists. We had a great discussion. And thank you, MCIA, for this opportunity. Thank you so much.
There is one more thing that I wanted to tell with regard to the question that was asked last. It is not about getting the right answers only, it is all about asking the right questions. Judges know that well. So it is like if I ask ChatGPT or even any artificial intelligence forum as to which are the sites out of which I can really download free movies, it would tell me that it's an illegal activity, it is piracy and I can't do it. But if I ask that what are the sites from which I should not download movies, it would give me the list. So that is where the human intelligence probably takes over with regard to the artificial intelligence. It is the whole art of doing justice lies in posing the right question and thinking while you actually are on your legs. So let's not really perceive it to be a situation that we are competing with AI. No, we want AI to be used. We really want it to supplement us. But only thing is that it never would be in a position to take over. That's all that we were trying to tell. Thank you.
Thank you for that interesting discussion. We now proceed to the second session on the topic Innovative Remedies in International Commercial Arbitration, Necessity or Guerrilla Tactics. For this, I would like to invite on stage the moderator for this session, Mr. Vyapak Desai, Partner, International Dispute Resolution at Nishith Associates. The panelists include Mr. Bijal Chhatrapati, Partner at Sagar Associates, Ms. Ishani Vora, Senior Director, FTI Consulting, Mr. Montek, Partner and Practice Head for Asia and Middle East at Osborne Partners, and Mr. Hasid Seth.
We can wait for a minute, otherwise we can start. So thanks a lot for holding on. I think few people are still coming back in the session. So again, warm welcome to everyone. Thank you MCIA for getting this organized. As the plenary said, this is an annual event happening for MCIA every year now, and hope to see you everyone every year. Coming to the session, right, we are going to talk about innovative remedies in international commercial arbitration, and more importantly, is it a necessity or guerrilla tactics? So yes, there are obviously many great innovations which can happen because of the way flexibility is provided in the international arbitrations. Unlike possibly in a court system where there is certain rules and procedures already set, arbitration is much more flexible and allows innovation to set in as part of the process. So this session is going to focus on that. It obviously gives me an immense pleasure to introduce the panel here. The first speaker so far as this session is concerned is Bijal Chhatrapati, and of course he needs no introduction to the Ahmedabad and Gujarat market, and of course nationally as well. But I'm thrilled to introduce him because I started my career with him. in Singhi and Company. So whatever good or bad you will hear from me today, you can attribute to Bijal bhai. I may be a bad learner. He of course gave me the right tools to learn. So thanks Bijal bhai for always being there to support and being part of this panel. Then we have Montek Mayal. I know him for a long time now, a great friend. He is possibly one of the pioneers to bring in the whole concept and mindset of getting expertise in leading evidence, particularly when it comes to valuation and damages. That's what we are ultimately fighting for. So in my view, he is the innovator from an India perspective to bring in that concept and making people realize how important it is as part of arbitrations, and particularly bringing his expertise from his international experience. He is now leading Osborne Partners throughout Asia, I guess, or maybe world, I don't know, but definitely a leading name in India. We also have Ishani Vora. She is based out of FTI Consulting's Mumbai office, and she has done several years of dispute resolution support services as part of the FTI group, which again I think Montek was part of earlier. So we have someone existing as well and someone from the past. That's the power of FTI, let me put it that way. And then again, thank you Hasit for joining. I would say he's the real counsel and arbitrator on our panel. And as all counsels do, he has been very, very kind to take up this brief at the last minute. We had Sandeep Dave who was to join us, but unfortunately he had some meetings in Gandhinagar. He is a group general manager of Gujarat Gas Limited, but he could not join us. And thanks Hasit for joining this panel. So with that introduction, let me put the topic in perspective. Innovative remedies, and I'm so happy that this topic I am moderating today as part of MCIS session. When we embarked our journey to set up MCIA, this was way back in 2014-15, and we thought there should be something that MCIA provides something different in terms of the rules, in terms of the way we are organized. We selected one of the best arbitrators and counsels all over the world and in India to be part of our council. In fact, in the rules itself, we were innovative, and I'll come to some of the aspects of those innovations. But one thing that we innovated at MCI as part of rules is that everyone knows when there are 3 arbitrators to appointed, typically one arbitrator is appointed by or rather 2 arbitrators are appointed by each party, and then the 2 arbitrators appoint the third. And we at MCIA say that no, MCIA will always appoint the third irrespective of the agreement between the parties, because we want to bring in certain kind of processes and the way the arbitrations are run, so that we have some control, or rather not control but guidance to see how the arbitrations are run. So right from the beginning, innovations has always been part of the culture at MCIA, and that's where the topic also comes in. When it comes to international commercial arbitrations, as I said, there is so much of party autonomy, so much of flexibility in processes. Arbitrator is the master of the proceedings in that sense, and so is the councils who can bring in a lot of innovations through either the institutional rules or otherwise. So we have divided this session into 4 broad topics. The first topic, Bijal bhai, I would like to bring you straight into the discussions. Unlike other remedies or other forms of dispute resolution, arbitration gives you a great tool to bring in what now we call as third-party funding. It's a concept which is there. It's not like an illegal concept or otherwise not known, but arbitration gives you that platform to bring in, because that the whole cost efficiency part can be taken care of through the third party funding. So maybe Bijal, if you can come in and give your thoughts on that.
Thank you, Vyapak, and thank you for your kind words. I'm happy to see that you have really flourished in your career. So yes, the significance of third-party funding or TPF is rather evident. What is, however, not clear and possibly disputed is the fact as to what is the nature and scope thereof. Maybe that is because the legal developments have not kept pace with this initiative. So in broad terms, TPF is something where an entity, which is not a party to a dispute, agrees to fund the cost of a party in return of a certain consideration. It could be remuneration, it could be some kind of reward, it could be a share, or it could be a premium. In the narrower sense, however, which is what is more prevalent, is funding on a non-recourse basis. So here, really speaking, the funder is an investor. If the claimant, typically it's the claimant, it could also be a respondent when there is a case of counterclaim. So if the claimant succeeds, the funder gets his money. If the claimant doesn't succeed, the funder does not get the money. This funding is also not restricted to a particular case. Today we see cases where a whole basket or a portfolio of cases are funded. Recently came across a case where an Indian company in the infrastructure construction industry got funding to finance enforcement of a basket of awards that it had. So which is after the stage of arbitration also, TPF has a role to play. So insofar as India is concerned, there is no law which says TPF is illegal. And in fact under section 23 also it is said that this will not fall foul of section 23. There are two old Privy Council judgments and recently the Bar Council case 2018 also recognized that third-party funding is here to stay in that sense. But this is all as far as litigation is concerned. Insofar as arbitration is concerned, the only reference possibly we find is in Schedule 5 to the 96 Act in the context of impartiality of an arbitrator, where they do consider that even if a financing party is related, then maybe you need to make that disclosure. So having said that, yes, and one more thing. Some high courts like Bombay High Court and Madhya Pradesh High Court have even amended Order 25 of CPC to say that they could implead a financier to give up security. That is as far as the legislation in India is concerned. So the mechanics, how it works is the three core elements, the way I see it, are the parties, the participants. Then of course is the terms, the funding terms, and then due diligence. So insofar as parties are concerned, obviously there is the party which is being funded, the party which is going to fund the funder, and the party which is being funded, legal counsel of that party, because the legal counsel also assumes significance. Because ultimately the funder is interested in knowing as to how the matter is going to be handled. So that is as far as the participants is concerned. Then in terms of terms, the funding terms, essentially they are a function of the amount which the funder is going to invest. It could also be a percentage of what the claimant will get in terms of the award. Typically, a formula involving both the elements is adopted. Due diligence, of course, is a no-brainer. The funder will have to see the winnability ratio, what are the rate of return is expected. One more thing that the funder needs to see is, assuming there is an award, is the respondent also resourceful? Does he have enforceable assets? Because ultimately, an award which you can't enforce is meaningless. So all these aspects will go into the due diligence bit. Having said this, now let us kind of approach as to what is this guerrilla tactics of necessity. I think the closest approximation of a working definition of guerrilla is to ask not as to why he fights, but how he fights. In a way that he is able to prevail or at least survive an opponent who is stronger. The objective being to either derail the arbitration, delay the arbitration, or even cut short the arbitration, abort the arbitration, make the entire process ineffective. However, within the four corners of the regulations, though bordering on not being ethical, but it is still within the four corners of the law. So with this background, I think there are a couple of scenarios where you can say that TPF could be misused or is being misused. The first facet of this third-party funding is that it can happen at any stage of the proceedings, which is where the first problem arises. Take a case where a respondent having gone or a claimant having gone somewhere into the proceedings or a counter-claimant having gone into the proceedings finds that things are not going his way. At that stage, if he involves a third-party funder, essentially to create a conflict of interest scenario with the arbitral panel, the entire proceedings go for a toss. So this is one area where possibly it is used as a guerrilla tactic. It's not a necessity at all. Because mind you, every time a funder comes in, it is not because a party is not in a position to fund the litigation. It could very well be that the party is only sharing his risks. He is only trying to use his resources in a different way. Maybe kind of wanting to make his legal department a profit center rather than a cost center. So this is some area where TPF is misused. The other area which has also been coming up is when the funder does not honor adverse order costs. So there what happens is, assuming the claimant is really not a party of resources, ultimately should the matter go against the claimant and the respondent is ordered costs, what if the funder says, sorry, if I win I make a profit, I win, tails I lose, or rather I don't lose. So that scenario is another problem, and it is very crucial therefore to ensure that a funding arrangement necessarily should mean that he also honors an adverse cost. So very often this is possibly to be used as a guerrilla tactic. The third scenario is where a funder is a very powerful party, where he is able to create an imbalance amongst the parties. Take a case where instead of merely involving himself with case management, he involves in the day-to-day process of litigation. He could even, in a way, stop a possible settlement. So this is one area where there is a lot of concern. Also another offshoot, let us say the funder is a global major player. What if he was to target, particularly in an investment treaty arbitration, particularly target a smaller country, and he finances all litigations against one country? So this is another area where one needs to kind of be careful, because all this is now going to be a real possibility. So I think the way I look at it is, so long as funding is not a merely profit driven, it is not a speculative transaction where the interest of the claimant is merely a byproduct, one can then look at those cases as necessities. But otherwise it would border on kind of a misuse of the. Of course, all this is really happening because there is a huge vacuum in terms of regulations. There is nothing, no regulations, no disclosure requirements. I like to illustrate what happened once. In my case, my client, a major company in an industry, terminated a contract. The termination was fully justified because the counterparty had blatantly violated the terms. Nonetheless, we saw that the counterparty sued. It was an ICC arbitration. So we were quite shocked. As the proceedings went on, we saw that the best of law firms were employed by them, though they had very weak case. Plus, they had experts, including the Big Four. So my clients investigated and found that the funding party was really my competitor. And his really motivation was whether he makes money out of the litigation to harass me. So these ills are very possible, and unless we have a kind of a rigid regulation. For instance, I was reading somewhere, EU Parliament is now proposing that the share of a funder should be restricted to 40% of the take. So these kind of regulations, I think if they come, but so far as they are not, I would be a little circumspect. Thank you.
Sometimes in India, no regulation is a good idea. But of course, some of these issues do require. But Montek, very quickly, any experience sharing from an international perspective, you have seen it through the world. Any thoughts on this?
Yes. Hi everyone. I think Bijal has mentioned all the points I had thought about, but very quickly, and somewhat sort of slightly repetitive, but just for sake of completeness. So obviously, the use of third-party funding is in both scenarios, right? One is where the claimant or the injured party just doesn't have funds to pursue a meritorious claim. And the second, which Bijal touched upon, is increasing appetite of large companies to finance their claims through third-party funding. And these are not cash-strapped companies. These are well-resourced, cash-rich businesses, primarily because at the end of the day, it's all about risk allocation and capital allocation. And a big infra company which has, say, 10 claims ongoing, costing them $3-4 million per claim, that's a substantial amount of money that's being used for litigation instead of doing the business and investing in new projects. And in fact, I would go as far as to say that, except maybe investment treaty cases which tend to be very, very expensive, a lot of the commercial arbitration that we are doing internationally, most of them involve actually large businesses. So actually they have resources, but they've instead chosen to use third-party funding, which to some extent counteracts the point Bijal was making about the bargaining position you find yourself in. If you have a large infra company bargaining with a third-party funder, terms tend to be more fair because they have the countervailing part, the power. I think, but to go one more step perhaps further, I think overall, funders who are seriously in the business of funding claims are obviously profit maximizing, but they're not going to invest in frivolous claims, right? Because they are not in the business of making speculative bets. They're in the business of running a business, and poor allocation. And we have some examples just internationally. Big funds have sort of closed shop. Big funds have been absorbed by other funds because they made poor bets. So I think it's very important to bear in mind, and I think in the background of increasing cost in investment arbitration, in commercial arbitration, you need sources of capital. Traditional financiers, banks are not ready for such financing, I believe. The risk appetite is very different. So I think it's here to stay, right? It's a critical part, I think, of the ecosystem which is going to remain here. The only other a point I want to make is, and I think it's quite interesting from having seen this firsthand, in some way, third-party funding or institutional investors, I think, also help develop and promote best practices. I'll give you a simple example, and I think we will talk about this a bit later, is use of experts for damages and claims was frankly non-existent 10 years ago in India. And if experts were being used for damages assessment, we were the last call someone would make. The pleadings are done, evidence has been submitted, documentary request is done, we get a call 10 days before the deadline saying, oh, we forgot to quantify our claims, can you come on board and do that for us? So obviously when you are getting engaged so late in the process for quantum and damages, often the output is not as robust. There could be potential inconsistencies also with the legal position, the quantum position you want to pursue. And bizarrely, third-party funding has helped that. The simple reason is no funder is going to pursue or invest in a claim prior to a proper merits and quantum analysis. So in a very weird way, it's actually forcing lawyers and clients to look at their damages case upfront, which actually is,
see what is the real claim.
Precisely, make an informed decision, because often, look, commercial arbitration, I wouldn't say 100% of the time, but 90% of the time is about the money. So you want to pursue claims which have merit and which will be substantial.
That's why they are commercial.
That's why they're commercial, right? I mean, there are issues in India when they become extra commercial. But I think the point is there are obviously these other ancillary benefits. Sometimes a sophisticated process brings to the overall system. And I mean, I can't just be pro funding. I have to say something negative about funding. I think the only concern I see, and I genuinely see this, and it's actually right what Bijal said. I do a lot of investment arbitration work, and one thing is there's sometimes a balance where you see funders deploy a lot of capital in a way to sort of overwhelm the state and state-owned entities. And this is because state and state-owned entities tend to be more prudent in their spending. But I've seen funders deploy 20s of millions of dollars on an arbitration, overwhelm the whole system with experts and witnesses and documentation, which again, it's a balancing act. They have reasons to do it, but I think that's one risk we'll have to manage with funded claims.
Sure. So let's move to the next topic. I know we are also short of time in that sense. So of course, we can discuss this a little more in detail later. The other topic that we wanted to discuss in terms of innovative remedies is this whole emergency arbitration process. I think in my view, this is the most innovative aspect of international commercial arbitration, because one could not go to arbitration till the time the tribunal is formed, and it takes 30 days or 90 days depending upon number of arbitrators to even form a tribunal, where to go. People used to rush to courts, and that was not the whole idea of doing an arbitration in the first place. So emergency arbitration is one big tool for getting urgent reliefs. And again, MCIA has been a pioneer in this field. I think Matt is here and Madhupeshwar is here. When we were also drafting the rules, everyone said in 2015 that Law Commission report in 2015 suggested for emergency arbitration, but the Parliament rejected, and therefore MCIA rules should not talk about emergency arbitration. But we said no, we need to go with the international mindset, and there is nothing illegal about it. And now we have Amazon versus Future confirming that there is nothing wrong about having an emergency arbitration. So in that sense, that point has been vindicated. But I'll bring in Hasit here to give a little idea as to whether emergency arbitrator is a necessity or a guerrilla tactic from a claimant perspective, because they are much more ready in an arbitration, and respondent is taken by surprise when in 14 days you get an award as part of an emergency arbitration.
Thank you, Vyapak. I think we have two regimes operating. One is the Section 9 regime in courts for ad hoc arbitrations, and the regime of emergency arbitrators, which we got to know from the Amazon future dispute, and its award was sought to be enforced in India. And also Niti mentioned an MCIA emergency arbitrator being appointed, and later that emergency arbitrator's award being challenged and upheld by the Ahmedabad District Court. So these two regimes will compete, but interestingly, as counsel and as arbitrator, I have seen what are the parties' motivations to file Section 9. Almost along with every Section 11 that is filed for appointment of arbitrators, a Section 9 application also is filed for interim relief. And that is not essentially for appointment of emergency arbitrators or an emergency award or emergency relief, but it's the idea that let's get as much as possible right upfront in the arbitration. So the idea is to make the other side deposit the amount in the court. The idea is to attach properties in Section 9 itself much before even the arbitration has started. And courts, considering that Section 9 is an aid to an imminent arbitration, have made it like really open and flexible, in the sense relief can flow to non-parties also. Non-parties can be dragged into Section 9. You can also have very innovative reliefs invented in Section 9, because while CPC is a guideline for Section 9 relief, but it's not bound by it. So that's one regime. The second regime, which rules for MCIA, for example, that's the Rule 14, which promotes like emergency arbitrators, where you can get instant kind of arbitration, arbitrator appointed as an emergency arbitrator. But I think in both these cases, the main focus would be that what's the relief being sought as an emergency. Why do you want an emergency arbitrator to be appointed, and why do you want an instant relief in Section 9? So unless both of these go on to be an aid to arbitration, then and then only I think the purpose of appointing an emergency arbitrator or getting some instant relief from Section 9 through courts would be helpful. Otherwise, if you see the pre-Commercial Court Act situation, where notice of motions in the original side were filed to get the other side to do something, like get an injunction against disposal of the assets or property attached or something, and the same pattern is being repeated in Section 9, and despite Commercial Courts Act, the same pattern is being repeated. Now, if the idea is to make the other side like bend on their knees and come to a negotiating table, a lot of these tactics are being used to just make the other side come to a negotiating table, and where you have an advantage as an award from an emergency arbitrator, or this thing. And we saw how in the Amazon Future Group was a dispute that while the award was sought to be enforced, the whole arbitration was sought to be sabotaged. That, like even when the next hearing should be held, was in dispute. So if the ultimate aim of getting an emergency arbitrator appointed, an emergency relief and Section 9 or Section 9 relief, if the purpose is only as a pressure tactic, I think that should be discouraged, because ultimate goal should be the fact finding. That arbitration has not given up on fact finding, although people like Toby Lindau and others have opined, and there is an ICC commission report also, that whether witness evidence should be of any relevance in international arbitration or not. I don't think so. Arbitration has given up fact finding. If it is to remain a parallel, as Vyapak likes to call it, an dispute resolution, he doesn't like alternative dispute, he says call it parallel dispute resolution. So if it's to remain that way, then the core needs to be fact finding, which is the main part of the arbitration. If we are going to do all the reliefs, all the fact finding, everything in emergency arbitration or Section 9, then we'll have a situation that will never come to the main this thing, and we'll then move to a regime which was there on the original side, or which has sort of become in commercial courts, very similar regime. If you look at Commercial Courts Act requires statistics to be published, for its performance. And if you look at the disposal ratio, it's like humongous. So what's that disposal ratio? It's probably interim orders. It cannot be decreased. If they are decreased, then I think we are working at rocket speed. So I was reading on the English judiciary website, which is judiciary.uk or something like that, gov.uk, that 8 commercial court judges in the Rolls building dispose of 1500 commercial cases a year, and after doing trials. Some of them may be settled, terminated, but the number is huge. So if Commercial Courts Act is actually coming at par with that, then we have a situation where we probably are more efficient than the English courts. But that's not the case. We're not doing trials.
Sure. Thanks a lot, and let me bring in Ishani here. I think again, international commercial arbitration gives you a great tool to bring in the expertise, which again you can bring in court system also, but it has its own challenges in terms of the manner and the stage in which you can bring in. So people use experts in very different fields. Of course, Montek would tell that it is a necessity. I would say whether it is also used as a guerrilla tactic. Of course, it's a question for both of them to answer, but what are the ways Ishani experts are now employed and deployed in the scenario, and how do you see that growing, and in terms of the topic that we are discussing? Is it really innovative from a perspective of necessity, or it's just a tactic?
Thank you, Vyapak, and good afternoon, everyone. I think, Vyapak, you took off some of what I was going to start with, which is even now, especially in India, we see that expert appointments sort of have a divide in the legal community. So we have practitioners and arbitrators who are pro-expert appointment, and we also even now see a lot of curiosity, but it's still a rarity in a different sort of section of the legal community where there are questions about the value that experts are able to bring to the table. So I just want to start out by saying that expert appointment itself is somewhat of an innovation even now, but Vyapak rightly mentioned that in international arbitration, and thanks to institutions like MCIA, even in India, experts are becoming sort of a fixture in some of the large matters where there are complicated questions at hand, and there are also a lot of technical or quantum issues which need to be dealt by an expert, or at least have assistance of such an expert to the tribunal. So I think my own view is that it is a complex decision in every arbitration, and it really depends on the factors at play. And Vyapak is right, I would always say it's a necessity, but to be fair, in cases where either you have a strong legal case coupled with a very straightforward sort of quantum problem or a technical problem, you need to weigh the benefits of having an expert on board, and it also depends on what the opposing party decides. So there are times where we see that opposing parties, where they know that they have a sort of weaker case, they could use it as a tactic to lengthen the process, because then you have so many more rounds, there are expert reports, there is a cross, there is more exhaustive documentation involved, etc. So it needs to be weighed on that sort of basis. And that's my opening sort of point. Within expert appointment, of course, we are seeing a lot of innovations as well, and I want to touch upon two sort of innovations we see in the appointment stage itself. So the first one I want to talk about is court-appointed experts, and I know there's a lot of talk about this when the question about hired guns and biased experts comes up, where we still see that there is concern both within council and arbitrator group that there are chances that the expert is a hired gun and they're not able to give out independent opinions and views, and therefore not able to independently assist the tribunal, as is the intention of having these experts on board. And two schools of thought again, it is a necessity, court-appointed experts could become a necessity in a few cases where they actually would help, and we have seen it, we have been appointed by courts and we've seen it help the process. So the first one is, it answers the bias question, and it really helps tribunals kind of oversee the process end to end, always being in the loop, and also cut down the communication or the relationship between the expert and either side, counsel or client, which kind of makes it more independent even on the face, because we do believe that party appointed experts can also be independent, but the presentation of that relationship is important, and I think court appointed experts kind of address that problem in part. The second benefit that we've seen is, because there is one expert on board, and I should back up a little bit. When I talk about court-appointed experts, there are 2 or 3 different ways you can think about it. One is where the tribunal or the court would go out and hire an expert on their own, and that expert would be the only expert involved in the entire proceeding. But there is also an alternative where the tribunal would ask both parties to together decide on an expert and bring them on board, and in which case tribunal is able to also get a buy-in from the parties for the common expert that they have appointed. And what we see is that in cases like that, whether tribunal appoints or the parties, the expert is given one set of instructions and therefore one set, and also one fact pattern, and that reduces the difference between the outcomes from both sides. Because if you have, and we all do believe that if you have very good experts on both sides, usually the difference in the answer would arise because of the difference in instructions and facts, and very few times you would see a dramatic difference because of finance or valuation theory or technical theory, for example. So it cuts out sort of that fat from the problem, makes it very lean, and makes it easy for the tribunal to solve. And in a party appointed expert, of course, you have like a parallel swap of reports, and that kind of makes it like a ship in the night. Everybody's working on different bases. So that's a good necessary reason for having a court appointed expert. And the last one I want to talk about is tribunals also have more power. We have also seen cases where there are experts which are appointed by parties, and then a third expert who's brought in by the tribunal to kind of work on the evidence that is provided by both sides and to make the best decision, because sometimes the questions remain complicated even after having heard both sides, given the level of technical issues involved and the differences that are seen in the conclusions that both sides draw. So those I think are the 3 sort of key reasons I would say it's a necessity. Just quickly on the tactics side, I think party autonomy is the biggest sort of reason we see that there is opposition to getting a court-appointed expert or tribunal-appointed expert, because parties always feel that they do not get a chance to put forth their case the way they want, and that of course is a right of theirs, particularly in international arbitrations in common law. So that's sort of the primary issue with court-appointed experts. The second issue we see a lot of the times is there is a lot of distrust, and we have faced this in cases where we were appointed by the court because you are not representing a side, even if we were appointed by both parties jointly. We still saw a lot of problems in getting data and full facts from both sides, and therefore the iterations on our analysis, it goes in a loop, and it kind of, it's like a filibuster. It doesn't help the process. It's supposed to make the process shorter, it makes it longer. So that's a big problem. And third problem that parties always have with such an expert is they sometimes view it like a delegation of the tribunal's sort of job of giving an outcome or an award. So we find that is a big problem, and that's when it's considered like a tactic by either party. So that's sort of the court-appointed expert.
No, thanks a lot. And maybe we have two experts here, so definitely Montek will have a different view.
Not necessarily.
Every time in a matter we have two independent experts, but still they both have very different view depending upon who they represent. In a lighter note, but Montek, any thoughts on the methods or the manners in which experts are engaged, whether it is a shadow expert, whether you employ hot tubbing, or you employ too many experts sometimes?
Let's appoint one first, and then we talk about over-experting. But I think on a lighter note, we have Madhukesh and Niti here together. This is a rare thing itself. Given this topic of innovation, maybe we should make it mandatory for all MCI clauses to have experts appointed in all their matters. I think that's the first start we can do. Now, I think very quickly, and to a lot of the points Ishani made, I sort of agree. The first point to note, and I'll start with the bad first and then go to the good. When you have simple problems, let's say you've lost 2 gold bars. You don't need an expert tell you what's the value of the gold bars, right? You can go and there's a market price for gold. You're done. Don't engage an expert for that matter. If you have unpaid invoices and the documentary evidence is solid, don't engage an expert for that, right? These are simple problems which can be done with documentary evidence. Where questions become more interesting, where there are claims of loss of profits, where there are claims about valuation of the shares, that's where experts are needed. Right? That's where experts can reduce the uncertainty in the outcome, in the evidence, to hopefully help the tribunal and the court make an informed decision. That's what we're there for. Right? We're not there as advocates for the clients instructing us. We're there to help the tribunal or the court make an informed decision. And we're able to hopefully offer evidence or analysis which is otherwise unavailable to the parties or the court or the tribunal. That's our job. Right? But coming to now Vyapak's view, when you get bad experts, you get bad answers, and you get large disagreements, right? And in fact, that's the guerrilla tactic we've seen, where you end up engaging experts who have extreme views, because it delays the process, it increases the cost. So I think it's that fine balance you have to kind of rely upon, and I think experts who are in the job of expert witness work will try not to do that, because for us, reputation is paramount. One bad award, one bad court judgment, and there goes our career. Right? So it's important to bear that in mind when you are instructing experts for your matters. Very quickly on the process, I think this is very important, and I hope we all can sort of learn from this and make the system more efficient in India. So Vyapak mentioned something briefly, which is I think very, very important, the concept of joint statements and hot tubbing. And I think that's one innovation we can bring in the expert witness process in India. What about my joint statements? Joint statements are nothing when you get the experts to meet, and they can agree to a list of issues that they can agree upon. So here are the agreements between the experts, and here are the key disagreements. So why is that important? Then the trial and any subsequent evidence can focus on the disagreements. If there are 3, let's focus on them. Let's make the hearing shorter, right? Let's make the hearings more efficient. So joint statements where the experts come together, they start the issues of agreements and disagreements, they jointly produce a report which sets out those disagreements and the reasons for disagreements, I think is one big step we can take in the domestic arbitration space. That then follows to hot tubbing. What is hot tubbing? Concurrent evidence. both experts are asked to give evidence together, right? So in that scenario, the tribunal or the court lead the cross-examination essentially. They ask the questions to the experts and they both have to answer. You can quickly see why that's helpful. If you have two extreme views and you force each expert to answer the questions, you will quickly see one person is most likely more reasonable. Whereas in cross-examination, sometimes, it's more like, for me, it's like more like gameplay. I often feel cross-examination is not about the truth, it's about just gameplay, right? So experts can dodge the questions, the counsel will only ask questions which are helpful to their case. So you don't really end up really getting to what Hasid also said, the truth behind it. What's the issues underlying the difference between the expert opinion? So I think hot tubbing and joint statements are two powerful tools. We can start using domestic arbitration. I think the third one I want to say is opening presentations. I've never seen a domestic arbitration have opening presentation. What is an opening presentation? Before you start, it's like direct, right? Or everybody's familiar with direct, I'm sure I see some nods. So in opening presentation, the expert ends up summarizing what he or she has done before he or she is cross-examined, right? Let's say it's half an hour, 20 minutes. He or she presents their views. What have they done? Why have they done it? And why do they disagree with their said expert? It's a great summary or a recap for both the tribunal, both parties, and then you can actually focus on the meat of the issues. It's obviously, all of the practitioners here know about this, it's almost always used in international arbitration. It's a great way of summarizing the case, and then everybody's on the same page, and you can focus on the cross. So those are the 3 steps, or the 3 things I think the process can be made better. Very quickly on your shadow experts, etc. I think, what do we mean by shadow experts? Shadow experts are what we call dirty experts or consulting experts. They're experts behind the scenes. So we're not engaged as independent experts giving evidence and testifying as independent parties. We're just helping the parties behind the scenes. Look, we've done that work. Mostly that work happens for respondents when they don't want to file expert evidence, but just use us in helping demolish their side's case. Otherwise, internationally, only often happens in very large cases where you can afford to pay multiple experts, right? But I think you can't really substitute, and I hope this is true, you can't substitute hopefully the advice or the opinion of an independent expert. But like I said, I think if used correctly, it should help the process.
Sure. No, I think this is very important, and I think, of course, I want to ask you one more question at least on the monetary remedies, particularly in long-term contracts. But I'll come back to you, Montek, on that depending upon the time. But other topic that we wanted to touch upon was international commercial arbitration in itself provides you the opportunity to choose institutions like MCIA or others, and those institutions provide a lot of rules which are otherwise not available from an ad hoc scenario. I'll just give you an example. Early dismissal of claims or joinder of parties. You go to an arbitrator in an ad hoc scenario and ask for certain remedies. It would be very difficult for an arbitrator in an ad hoc scenario to say, oh, I will apply some law and allow this kind of things, versus an institutional setup where joinder or early dismissal or expedited procedures are allowed. So maybe very quick comment from Bijal bhai on 1 or 2 topics on this, and then we'll open the floor first. And if we don't have more questions from the floor, then we'll go back to the speakers based on our list.
So I'd like to share something which has just now happened with me in an ongoing arbitration, which will show that if there's any debate or if anybody is on the fence as to whether it should be institutional arbitration or ad hoc, I think that debate should no longer survive. So this is an arbitration we are doing. As is typical in one of the first hearings, the 3 arbitrators, they decided the fee schedule and they said so and so rupees per session, per hearing. About dozen hearings later, they passed an order saying, when we had initially fixed the fee of X rupees and we had said per sitting, we had actually meant per session and not per sitting. So it doesn't stop there. So they unilaterally revised the fees going forward and saying, so now per session it will be charged for first half so and so, for second half so and so. It doesn't stop there. They said because this was an error we made on day 1, we are going to give retrospective effect to this, and therefore you will have to pay up for all the last 12 hearings. Now, I mean, how, and I'm really sorry to say, but these are judges of the Supreme Court and the High Court. So, I mean, this is something which I'm actually facing, but I think there's no doubt now that time for institutional arbitration has come.
So, one quick follow-up, because it goes back to institution, and while we are on an MCI conference, I'm not saying this because we are at one. I'm saying because I genuinely believe in this. The whole idea about timelines and process, and I've been a victim, and I'm going to be a victim again on Monday actually, where I've been called to give evidence multiple times in the same arbitration. So I'm going back on Monday in the box, and I've already gave evidence 3 months ago. And this would not have happened in an institutional arbitration. So, right, my longest cross-examination was 7 days over 9 months. I was called every other month to give evidence again, right? And there was just no process, no incentive also perhaps to shorten the and make the process.
So, of course, there are, as I told, there are a lot of innovations happening through institutional rules, and we can talk about some of them depending upon time. Particularly, I want to discuss early dismissal and expedited process. But before that, this time we'll first get audience in. You are waiting for your lunch, so you get the preference. Anybody has any question or comment on what innovations you have seen? Yes, Devang, go ahead.
Well, I really had a couple of questions. I would rather restrict to one. Only confining myself to the subject that we read, that is it necessary or is it perceived as guerrilla tactic. And I hear that the gentleman has to again now step back into the witness box for a very longer sessions that he should look forward to. I just want to ask him on a personal note as to, does he really find this to be a guerrilla tactic, or is it really a necessity that everybody will have to undergo this, because ultimately what we are probably trying to look at is resolution of a commercial dispute. And in so many words, when we talk of resolution of commercial dispute, of course you would not be siding with anybody, or you would not be party to the very dispute that is happening for which you are entering as a witness, but then of course you are going to step in as an expert witness. How you as a person find this is what I would want to know from you, as to whether it really is a necessity or is it just a guerrilla tactic. Thank you. I am Devang, by the way, and I am here to ask you questions. Thank you.
Yes, I heard you in the last time.
We have planted.
So just to be clear, just to be very guerrilla tactic. Just to be very clear, is it? Are you asking whether the use of experts itself is a necessity or guerrilla tactic, or the extension of the cross-examination is a necessity or guerrilla?
In a combined way, if I can say that. So, because to me, it always is both.
Understood.
Yes.
So my short answer is yes and no, and I'll elaborate. The yes is, I think it's a necessity, expert evidence, not in all matters. Like I said, I'm not sure if you've heard that, but if you have unpaid invoices and you have documentary evidence, you don't need me, right? And that's where you cross the line of over-experting. So it's a guerrilla tactic in that scenario, because it extends the timeline, increases the cost, etc. But when the questions like loss of profits in 20-year projects, questions about valuation of shares for exits at private equity funds, those are difficult questions. And I genuinely believe this, that people like us can help reduce the uncertainty and help a tribunal make an informed decision. So the first part of the question, your question's answer is yes, it's a necessity. The second is, do I need to be cross-examined for 7 days over 9 months? I think no. I think it's a guerrilla tactic, because either you can, if you want to cross-examine for 7 days, let's block a week. Let's avoid the double incurring of costs. I have to prepare every single time. I have to incur costs. My time has some value associated with it. There's a cost of the venue. There's a cost of parties flying in. Let's reduce that, right? And do you really need to cross-examine for 7 days? I would say no. In most international arbitration, if I'm giving evidence for more than 2 hours, that's a lot. My longest examination in international arbitration is 6 hours, and that was a $1.5 billion claim, right? And this claim I was testifying for 7 days was 50 crores. You could have really done the job and asked me limited questions. I think the difficulty here is, if I may, and I'm sort of past, I am perhaps crossing the line a little bit now. The problem is, this is a style of advocacy, and I think you could focus on the questions that matter to me. I get asked legal questions and factual questions as an expert witness. That's a no-no, right? Any international tribunal or court would say, hold on, he's not here as a fact witness, he's not here as a legal expert. Ask him the question on his merit and on his analysis. And I am now obviously seeing tribunals do that. But it's the reluctance I feel sometimes for the arbitral tribunal to engage in that, or to be involved in that, which pushes the question. Like on the same example of 7 days, 9 months story, I was getting asked questions about how far is your factory from Mumbai. There's Google Maps for that, right? It wasn't even relevant to the analysis I was doing. It's just that practice, I think, makes a guerrilla tactic, because the respondents obviously sometimes have an interest in elongating the arbitration.
We as lawyers will really have to discourage you, and therefore these things would come to our rescue. Then when you don't even know that basic as to how much time it takes, how will you really tell us as to what would happen after 20 years? And therefore we are well within our rights, I believe, to ask you those questions.
Engage us earlier and we'll help you answer those questions.
Thank you so much. I would really wish that you step into box someday.
Yes.
Hi, I'm Keval Shade, very similar to what Montek and Ishani do. Would you consider parties appointing experts or technical experts, not just accounting or valuation experts, but other engineering experts, also as an arbitrator on the case? Would that be also one of the innovative ways?
Either Hasid or Bijal, I think you guys can. Yeah, please.
Yeah. Thanks, Keval, for the question. I think a lot of technical arbitrations where technical issues are involved do have engineering experts very commonly. So for example, railways, usually I did the monorail arbitration where all three were railway engineers. You know the DMRC case, I mean all three were, it's an engineer's award, and there is a remark there that, you know, like all three were railway engineering experts, and their award should not be evaluated as if it's a legally trained person's award. And internationally people have taken a lot of objections when I wrote about it. So those experts are very common, I mean engineering experts. Fire related issues, insurance arbitrations, those are extremely common. I mean to have those people as arbitrators.
Just one point, Vyapak. I agree with you, and probably this question also stems out from the fact that, you know, a lot of parties are reluctant because one of the parties would have, you know, appointed ex-justice or, you know, high court judge, and, you know, then the other party goes into a dilemma whether you want to take that chance with a relatively lesser, you know, experienced arbitrator on the panel, and that is where, you know, a lot of experts then do not get appointed as an expert, not just engineering, from accounting or valuation point of view.
No, it's a more mindset issue, I guess. Any other questions? Please? Sorry, you want to Montek wants to.
I think because I've seen this. I think it goes both ways. So I think your question has two parts. One is experience, one is skill. I'm going to not answer this experience part because that's a different battle. On the skill part, having a wit. On the other hand, to your counterpoint, and I've seen this like Asid mentioned in certain cases, in fact even for shareholder disputes, not seeing this, where the principal question is technical or valuation of shares, let's say, I think then skill trumps the other person being a judge, because then those two other arbitrators will rely on you much more heavily for that answer, right? And I've seen that practically play out. So I think it depends on the issues. I think the reluctance sometimes is right, because often many of us don't have the legal background and issues are complicated and there are legal issues involved. So I would never recommend having a chair as an expert witness, someone who's an expert or non-lawyer. I think when the question principally is a more technical one or a valuation or accounting one, I think both other arbitrators will actually rely on that person more, because that person will
I think it's more of a party nomination issue unless institutions appoint. Yeah, maybe last question and then we'll go back to our speakers for last comments.
Good afternoon, Manal. Bijal go with this side. I have a question for the panel. Whether the challenging of an arbitral award in the section 34, after the enforcement of that award, can it be a necessity or it can be a tactics played by the other side? Because the facts are prima facie, considering that point.
So unless Bijal, you.
No, I believe if the enforcement has taken place without difficulty, obviously it will be a guerrilla tactic.
Guerrilla tactic.
It has to be challenged before the enforcement, of course.
Very well, sir.
Thank you.
But then at least the timelines provided in 34 will take care of it.
No, because after the period has expired, the cooling period after it has expired.
At least the law, the way it is developed, the strict timeline for the challenge has been upheld by courts, that courts possibly could maximum 90 plus 30. So I think generally I would assume by that time it would be enforced. Otherwise it would be another story. But so we obviously can discuss this over lunch because that's what is waiting for you all. But any last comments, Bijal bhai or Asit or?
Just to answer your question, I think the choice of an expert or a judge essentially boils down in practical terms as to who is making the choice. If as a lawyer I have to make a choice, I possibly prefer a retired High Court judge because I don't know the expert anyway. Well, if as a client he's going to make the choice, he might prefer the expert. It all depends. It's in practical sense, that's the way it will possibly be handled.
So thanks a lot. I think Niti told me to end it at 2, which is what I am. It's 1:59. So maybe last comment to Ishani, being the youngest member on the panel.
Yeah, thank you. So I think just to close off, be it questions about expert appointment, third-party funding, or even some of the legal points that we discussed here, I think the theme that really comes out, whether or not it's a necessity or a tactic, really depends on the context and the problem that is at hand. Everything can be seen as a necessity or a tactic depending on who is the party involved, what is the constitution of the tribunal, what is the fact pattern like, what is the complexity, etc. So I think there is no clear single answer to any of these points, and each of them have been implemented in a lot of cases for a reason. So I think that's sort of my conclusion.
Okay, thanks a lot. Only thing remains for me is to thank all the speakers. Asit for coming in, Montek and Ishani, and of course Bijal bhai, as I said, it's a privilege for me to have him on this panel. And thanks Niti and Madhupeshwar for getting this organized. Only thing I can say is that the topic is so wide. I think we need a whole day on this rather than 1 hour. So maybe that's our ask from MCIA next day. So thank you, thanks a lot.
I just want to thank Vyapak, who's decided to share his birthday with us here on the panel. So special thanks to Vyapak for joining us on his birthday today.